Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Welcome to the Environmental Evolutions podcast, where we explore the changing landscape of environmental law and policy. My name is Scott Novak, and I work as an environmental attorney at Baker Botts. As a reminder, any views expressed on this podcast are not necessarily the views of the firm. Today's episode tackles what may be one of the most consequential environmental regulatory actions in more than a decade: EPA's final rule repealing the 2009 endangerment finding for greenhouse gases. The endangerment finding was the legal foundation for EPA's regulation of greenhouse gases, in which the agency concluded that greenhouse gases endanger public health and welfare. That determination has laid the groundwork for virtually every major federal climate regulation since, from vehicle standards to power plant rules. Now, EPA has finalized a rule rescinding that finding. What does that mean legally? How does EPA justify reversing a prior determination? What happens to the body of regulations that relied on it? And how will the courts respond? To unpack these questions, I'm joined once again by my colleague, Allison Watkins Mallick, Section Chair of Baker Botts' Environmental Safety and Incident Response Group in San Francisco. Allison, welcome back to Environmental Evolutions.
Thanks for having me, Scott.
So to start off, what are EPA's core justifications for repealing the endangerment finding?
EPA provides several legal arguments in the final rule to justify the rescission of the endangerment finding. Most of these are based on EPA's new interpretation of the text of the Clean Air Act itself. So first, EPA is proposing a narrower approach to the regulation of air pollution, one that focuses on pollution that harms public health or welfare directly through local or regional exposure, rather than looking more broadly at the effects of global climate change as they did back in 2009. Second, EPA argues that Congress legislated, when it passed the Clean Air Act, with longstanding legal principles in mind, and specifically the principle of causation. EPA concludes in the final rule that emissions from new motor vehicles and engines in the United States do not have a sufficiently close causal connection to the adverse impacts identified in the endangerment finding to fit within the legal meaning of cause or contribute to the endangerment of public health or welfare. Third, EPA states that the endangerment finding implements what's called the major question doctrine, which was articulated by the Supreme Court. That doctrine holds that clear congressional authorization is required when actions present questions of, quote, undeniable political and economic significance. So in light of this Supreme Court precedent, EPA concludes now that Clean Air Act Section 202, under which the endangerment finding was made, does not contain the requisite congressional authorization for it to regulate in response to global climate change concerns or to determine the nation's policy response to such concerns. And there's one more basis that EPA provides in the final rule. EPA concludes that eliminating all greenhouse gas emissions from motor vehicles and engines in the United States would have no material impact on global climate indicators. And thus, regulation of greenhouse gas emissions from motor vehicles would be what EPA calls futile. EPA says that this futility analysis supports its reading of the text of the Clean Air Act to be one that is focused on pollutants with local or regional effects. EPA also says that rescission of a regulatory program is justified if that program imposes immense burdens without furthering any statutory objective. So these are all legal bases that EPA provides for its final rule. And EPA states in the final rule that any one of these bases can independently provide sufficient justification for the rescission of the endangerment finding. I'll note one more thing about how EPA has supported the final rule, and that is that in the proposal, EPA included an alternative basis for rescission based on a scientific analysis. That would have involved EPA making a new finding about endangerment based on its review of the scientific record. EPA did not finalize that alternative basis for the rescission and instead is relying on these legal arguments to support its final action.
That's interesting, Allison. So why do you think EPA backed away from relying on those scientific arguments?
What EPA says in the final rule is that it received comments that were both supportive and critical of the proposed alternative approach based on the scientific review, but that it would be inappropriate for EPA to respond or finalize the alternative proposal in light of its determination that there's no statutory authority to regulate mobile source greenhouse gases under Section 202. It's possible that EPA may have felt that it has sufficient bases to support the final rule already with the numerous legal arguments that they've articulated, and that the scientific alternative was not necessary. I also note that the scientific argument has been subject to some legal challenges already, with lawsuits filed over the development of the scientific analysis that was relied upon by EPA in the proposal. The last thing I'll note is that if there was a rescission based only on a scientific finding, that could potentially be more easily reversed in the future, just based on how a future EPA interprets the scientific literature at some point in the future.
So, Allison, thank you for that. Just to clarify for our listeners, the difference between the legal reasons and the scientific reasons. You mentioned that one of the legal reasons EPA has put out there for this rescission is that greenhouse gas emissions do not cause or contribute to the endangerment of public health or welfare. From one perspective, that does sound like a scientific determination. So can you further explain that distinction for us?
What EPA is doing in the final rule is looking at the causal chain linking emissions from new motor vehicles and engines in the United States to any potential endangerment to public health and welfare associated with global climate change. And what EPA says is that there's a number of steps that have to happen in order for you to link those specific emissions to any potential consequences from global climate change. And because that mechanism or that connection requires those multiple steps, it's too far attenuated under the meaning of the cause or contribute standard to satisfy an endangerment finding. This is different from what EPA had proposed as an alternative scientific basis in the proposal, which would have required EPA to make a finding about the impacts of greenhouse gas emissions on public health and welfare, simply based on the status of the scientific literature around climate change.
Got it. Thank you. That's a helpful clarification. So if the repeal stands, what happens to existing greenhouse gas standards for vehicles and power plants?
If the final rule itself stands, then the greenhouse gas standards for new motor vehicles and engines are rescinded, and the final rule itself takes that action. So that's an immediate consequence of the final rule. However, the rescission does not directly impact standards for power plants. EPA is still working on a reconsideration rulemaking related to the power plant greenhouse gas standards, which were promulgated under a different section of the Clean Air Act, Section 111. So EPA will need to finalize that action to have any impact on those standards.
Given the Supreme Court's recent administrative law decisions, including West Virginia versus EPA, how might the court's view of agency authority shape any litigation that comes from this?
I think the court's view of agency authority will be very important. EPA is relying heavily on the court's recent administrative law opinions to determine what is the best reading of the Clean Air Act and define the scope of the authority granted to it by Congress in the statute. Whether the court agrees with EPA on what the best reading is and the scope of EPA's authorization under Section 202 will be key issues in the litigation.
Could the Supreme Court ultimately revisit or clarify Massachusetts versus EPA, the Supreme Court case back in 2007 that directed the agency to consider whether greenhouse gases do endanger the public health or welfare?
So in Massachusetts, the court concluded that the broad language in the Clean Air Act created flexibility for EPA to address harms that Congress may not have specifically anticipated when it enacted the provision. EPA is now saying that Congress did not intend for greenhouse gases to be the type of pollutants that require regulation under Section 202. So you can kind of see the tension there. It is possible the court could address this, but it's also possible that one of the other legal bases that EPA has provided for its action may end up being the focus of the litigation.
So clearly, this is a really big decision, a really significant final rule from EPA. How should companies be thinking about their long-term climate strategies in this kind of regulatory environment?
Well, unfortunately, we're going to have to be prepared for uncertainty for the time being. We expect that the final rule will be challenged in court, and it will take months, potentially years, for that litigation to work its way through the court system. In the meantime, there could be requests for a judicial stay of the rescission rule, which would have the effect, if granted, of leaving the current vehicle greenhouse gas requirements in effect. For industries that are outside of the automotive sector, the focus next will be on the reconsideration of the power plant greenhouse gas emission standards, which is expected to be finalized soon. That final action will provide some clarity in the short term about EPA's position, but uncertainty in the long term as a result of litigation that will flow from that finalization. Finally, I do want to note that companies may want to pay more attention to activity at the state level. We may find that states may be more willing to address greenhouse gas emissions themselves in the absence of EPA. EPA has provided rationale in the final rescission rule about why it believes these kinds of state regulations of greenhouse gases would be preempted by federal law, even with EPA's final action on the endangerment finding. But there is not legal clarity on that, so this is an issue to watch.
Well, we will definitely be looking out to see what's to come, both on the federal and state level on this issue. Allison, thank you so much for joining us today.
Thank you for having me.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts, LLP, for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.